Hi, this is Katie Abernethy with the Noble Law Firm, and today I'm addressing a question that we sometimes get from potential new clients. And the question is, am I a whistleblower? Oftentimes, these potential clients have observed some inappropriate or fraudulent or illegal activity at work and want to know if they are entitled to whistleblower protection. Whistleblower protection basically means protection from retaliation. So to access the protection of anti-retaliation laws, you first have to engage in what is called protected activity. Now, as the word activity connotes, this means more than just having knowledge of a crime or fraud. So just because you know that your boss is engaged in criminal or fraudulent activity, and just because your boss knows that you know that they are engaged in criminal or fraudulent activity does not make you a whistleblower. Most anti-retaliation laws require that you have to do one of three things to qualify as a whistleblower and to be entitled to the protection of anti-retaliation laws. One of the ways, and probably the most preferred way to ensure that you're entitled to whistleblower protection, is to report a crime or a fraud to the appropriate state or federal enforcement agency or authority. The second way to become a whistleblower and to become entitled to protection under some anti-retaliation laws is to report the crime or fraud to an appropriate person internally at the company. So, for example, you could make a report to the chief executive officer. You could make a report internally to the chief compliance officer, or if your company has a compliance hotline, you could contact the hotline. A third way that under some statutes you can become a whistleblower and become entitled to the protection of anti-retaliation laws is to take action to oppose or prevent a violation of the law or a fraud. That is particularly an option that is available to you if the particular crime or fraud at issue is the submission of false claims for payment to the federal government. Some anti-retaliation laws have much more stringent requirements than others, so it is really important that you follow the requirements of the particular law or regulation that applies to your situation. As one example, the regulations for the Dodd-Frank Wall Street Reform and Consumer Protection Act are rather stringent and require that you report potential violations of securities laws in writing to the SEC before you become entitled to anti-retaliation protections. On the other end of the spectrum, as mentioned earlier, the Federal False Claims Act merely requires that you take action to oppose or prevent a false claim from being submitted. Employers often deny having received oral reports of crime or fraud when made to their upper management, human resources departments, or compliance offices. So it is very important for your own protection that you make your report in writing and that you retain a copy for your own personal files. And the second part is key. Sending a report over company email or a company IM platform still leaves you exposed because the company will cut off your email access if it terminates you, leaving you without proof that you made a report unless you have printed and saved a copy of your communication. If you are concerned that reporting a crime or fraud could result in retaliation against you, you should seek counsel to ensure that you are making an appropriate report that will entitle you to the protection of federal or state anti-retaliation laws. Here at the Noble Law Firm, we regularly counsel potential whistleblowers and represent their interests in pursuing relief when they experience retaliation. I hope this information has been helpful. Thank you very much for listening.